Today, the Supreme Court heard one of the biggest reproductive rights cases in years. The justices deliberated over a Mississippi abortion ban after 15 weeks of pregnancy. Their ruling on Mississippi's law could have far-reaching ramifications beyond the state. After about 2 hours of hearing arguments, all 6 conservative justices indicated that they would go with allowing states to roll back abortion access. So we want to bring in Jennifer Popik to talk about today's hearing and what it means in the ongoing abortion battle. Jennifer is the legislative director for National Right to Life Committee. Jennifer, welcome to Quicktake. What is your reaction to this news after we're now hearing that the conservative members of the court are potentially going to vote in favor of rolling back abortion access?
Sure. I would say from the point of view of National Right to Life, we're very encouraged by what we heard today. Now, it's difficult always to know for sure, just based on oral arguments alone, what sort of outcome we're going to get, but we're encouraged. I think based on the questions, there's a majority of justices who seem likely to in some way either explicitly overrule the Roe versus Wade decision as modified by Casey, or to do something a little narrower, at least allowing more pro-life laws at an earlier stage than viability. So either outcome, I think we're encouraged.
So tell me a little bit about the viability question here. Does your organization feel that the viability should be changed, should be addressed by the Supreme Court? And if so, how likely do you think that is, given that, it would be really unprecedented for the court to overturn something like Roe v. Wade? They've never done something like that before.
No, that's correct. I mean, it's been, 30 years since the last sort of landmark case, which was the Casey decision. And there's just been, a real pattern here, although we have this undue burden standard that was sort of governing and saying you can't put an undue burden in the way of a woman prior to viability. It's left a situation where it's very difficult to pass laws to protect unborn children. So we're certainly in favor of moving that back and giving states, state legislatures passing laws, working through their own process to say, hey, this is a point at which we want to protect the baby. Maybe it's the baby can feel pain. Maybe it's the baby, has a heartbeat and brain waves. There are other places at which the state might come in and say, we have a right in the life of this unborn child, and be able to pass more meaningful restrictions.
Sure, but at 15 weeks, even if a fetus was given a lot of life-saving efforts from doctors and experts, it would be really hard for that fetus to survive. So how do you kind of defend that argument?
Sure. The Mississippi law itself does have a lot of exceptions for health of the mother, life of the mother, that sort of thing. We think this is a very developed baby. Yes, it is not able to fully survive on its own. Even, the earliest preemie babies are surviving at 21, 22 weeks. So, this is a very late stage of pregnancy. This is a very developed baby. This is one that has met a lot of, physical milestones, and a baby that's likely to survive. And, if the pregnancy continues. So this is a stage, at which I think a broad swath of the American people would say, there might be some differing opinions on abortions early in pregnancy, but this is a very late stage of pregnancy.
I want to talk about the state angle here, because I know that your organization and the conservative justices are leaning, now that we know how they're reacting to these arguments, they're leaning towards allowing states to decide on this issue. What do you envision that looking like for the country moving forward? It would seem that the South would pretty much enact bans on abortion, and the North and more liberal states wouldn't do that. What do you think that does to the makeup of the country and the electorate?
Sure. And we don't know what the Supreme Court's going to do. If it's a full reversal of Roe as modified by Casey, I mean, this would be a battle then that was fought at a state by state level, but it's possible the court does something a little short of that. But also would be good from our point of view. Yeah, we absolutely see that there's, certain states like New York and California have, very permissive abortion laws in their states, not just limited to the South, like Ohio and other places like that, that would, do more to protect unborn children. And I think what we would look for in a lot of states is really common sense, sort of look at a point where a woman has an opportunity to know she's pregnant. You have a set of exceptions for, like physical health problems that a mother might have, or clearly the life of the mother. I think states will do a patchwork of things, and, that will that will mean some states, a woman will be in a position to, if she's going to seek abortion, she'll need to do it sooner than if she lived in New York. So if the court goes as far as overturning Roe, it will return the states to sort of a patchwork approach.
And let's talk about Mississippi in particular, which is the subject of today's hearing. There's only one remaining clinic in Mississippi, and the state already had a 20-week limit prior to this additional 15-week law that's in question. That already put a lot of limits on the number of people who were able to seek abortions in the state. Does it feel to your organization that that wasn't enough?
Well, I think, what happened is a lot of states were very enthusiastic when they saw the makeup of the new makeup of the Supreme Court, and a lot of states were, hopeful to get laws in front of the court. I know that the one clinic in Mississippi was doing abortions up to 16 weeks. And I think the state of Mississippi was trying to assert an interest, like, look, that abortions at this stage are actually very dangerous to the woman. And look, babies at this stage feel pain. So, whether or not what might be going on at the time, we wanted to be able to protect these babies in law. More clinics couldn't feasibly open in the state, so it was a point about drawing attention to the humanity of the unborn child, showing these markers where the state wanted to protect.
Final question to you, Jennifer. I know that a fascinating and unprecedented argument being made in this Mississippi case in front of the Supreme Court is that the undue burden thing is no longer a valid argument because women and men are equal. Women have more access to capital now, according to these attorneys, so they are able to be moms and care for a child. It's not an undue burden anymore. How do you square that, though, with the fact that the majority of women who do seek abortion services in this country are low income and don't actually have equal access to capital?
Well, what I say is I think we need to do more work as pro-lifers to connect women with pregnancy resources centers, with the resources that they are able to get through the state Medicaid programs, through WIC, through, there's so many sorts of different resources out there. I think the ability to put a baby up for adoption is a far simpler process now than it was when Roe was decided. And there was a focus today on the fact that there's so many state protective laws about if a woman has a baby, she can drop it off, no questions asked. There is no sort of ongoing requirement for to be an active mother of the child. What we're talking about is protecting sort of the unborn life.
Jennifer Popik, Legislative Director for National Right to Life Committee, thanks for joining us. We're going to continue to cover this story as we get updates from the Supreme Court. For now, I'm Madison Mills in New York.